Ladies and gentlemen, gather around for a story about a very helpful AI called ChatGPT. This little bot can do a lot of cool things, from answering questions to writing essays that would make even Shakespeare jealous. But, as with any good thing, there are those who misuse it. And believe me, it's not pretty. Here are 8 real cases or real news stories documented by reputable sources of misuse with ChatGPT where individuals or lawyers got caught. Case 1. Lawyer used ChatGPT in court and cited fake cases. In a routine personal injury suit against an airline, a lawyer used ChatGPT to prepare a filing and cited fake cases delivered by the AI bot. This led to a federal judge considering sanctions against the attorney and the legal community dealing with one of the first cases of AI hallucinations making it to court. Case 2. Lawyers have real bad day in court after citing fake cases made up by ChatGPT. 2 lawyers from the firm Levi Dow, and Oberman cited 6 fake cases invented by ChatGPT in a lawsuit against Avianca Airlines. U.S. District Judge Kevin Castell tossed the lawsuit and imposed a $5,000 fine on the lawyers and their firm. Case 3. Lawyers cited 6 fake cases made up by ChatGPT. Judge calls it unprecedented. Lawyer Stephen Schwartz admitted using ChatGPT to write court filings that cited 6 non-existent cases. The lawyer greatly regrets relying on the AI tool's content and faces potential sanctions in the Southern District of New York Court. Take these 3 cases of lawyers, for example. They used ChatGPT to come up with fake court cases and tried to use them in their arguments. I mean, come on guys, you're lawyers. You're supposed to know how to research case law and make convincing arguments based on facts, not just rely on an AI chatbot to do it for you. And let's not forget about that one lawyer who faced potential sanctions for using ChatGPT's content in court filings. Seriously, man. You're risking your entire legal career just to save a little bit of time on research? That's like using a magic 8-ball to make court decisions. But what's even scarier is the fact that these are just 3 examples of many cases where people have misused ChatGPT. It's a reminder that we need to use AI responsibly and ethically. Otherwise, who knows what kind of trouble we could get ourselves into. So, next time you're tempted to use an AI chatbot like ChatGPT, remember these cautionary tales. And if you're a lawyer, for crying out loud, do your research the old-fashioned way. Don't rely on a chatbot with a sassy name to do your job for you. Case 4. Creating malware and misleading messages. Some individuals with malicious intent have exploited ChatGPT's language generation capabilities to create computer programs called malware. Malware can harm other computers, steal information, or gain unauthorized access to networks, posing significant risks to individuals and organizations alike. Additionally, ChatGPT can generate messages that convincingly mimic human-written content, potentially leading to deception and misinformation. Not cool, ChatGPT! Case 5. Academic dishonesty in educational settings. ChatGPT has been misused by students seeking to cheat on their homework or essays. With the ability to generate writing on various topics, students may use ChatGPT to complete assignments without putting in genuine effort or understanding the subject matter. This undermines the educational integrity and can have severe consequences for students' learning and future career prospects. With the ability to generate writing on various topics, some kids are taking the easy way out by letting ChatGPT do their work for them. How are they going to learn anything that way? Case 6. Biden v. Nebraska. This case involved the forgiveness of federal student loans by the Biden administration, which was challenged by multiple states. The Supreme Court ruled on June 30th, 2023, that the Secretary of Education did not have the power to waive student loans under the HEROES Act. So much for student loan forgiveness. Am I right? Case 7, Greta v. Bollinger. This landmark case addressed affirmative action in student admissions. The Supreme Court held that a student admissions process that considers race as a factor does not violate the Equal Protection Clause as long as it takes into account other individualized factors. The decision largely upheld the court's previous decision in Regents of the University of California v. Bakke, 1978, and allowed race to be a consideration in admissions policy. Now, I know some of you might be thinking, but what about me? What if I don't come from an underprivileged background or belong to a minority group? How will I ever get into college? Well, don't worry, my fellow non-misfits. There's still hope for us yet. Just start your own charity, like Helping Hands for rich kids who need a college education, and boom, you're in. Leave it to the rich to find a loophole. Thank you, Greta v. Bollinger, for reminding us that the American dream is alive and well for some of us. Case 8, Students for Fair Admissions v. Harvard. In this case, Students for Fair Admissions challenged Harvard University's undergraduate admission practices, alleging that they violated Title VI of the Civil Rights Act of 1964 by discriminating against Asian Americans. The Supreme Court held that Harvard's admissions program violated the Equal Protection Clause of the 14th Amendment and Title VI, effectively overruling previous cases and restricting the use of race-based affirmative action in college admissions. Looks like Harvard is about as good at fair admissions as these kids are at doing their homework, which is to say, not good at all. I mean, if their admission process is anything like their essay writing process, they're probably just pasting random quotes and hoping for the best. But hey, at least now they can all bond over their shared experience of getting schooled by the Supreme Court. So, my friends, don't let ChatGPT fool you. Use it responsibly, or you might end up in hot water like these folks. Thanks for coming to my chatbot stand-up routine. I'll be here all night.